The next speaker is Sean Cash, who probably may have been well known to many of you. He's had over 23 years of experience at the bar and practices in coronial matters, disciplinary, occupational health and safety, and also common law proceedings. He often is in coronial inquests in relation to deaths arising in the medical context. He regularly appears for medical practitioners with the Victorian Board of Medical Practitioners in the show cause type hearings. He has a criminal practice largely involving health practitioners concerning conduct alleged to have occurred in the context of their practice. You may not have seen him a lot recently in court, as with Mark. The sex matters that are involving both of them are in camera, and therefore the court is closed. He's had a different type, or his talk's going to be pitched at the different type of client, perhaps a more articulate client, one where they're not the 2 a.m. phone call, where he's had time to prepare, sit down with the client, discuss probably tactics and the background. So he's coming from a different, totally different angle, and I introduce Mr. Sean Cash.
Hello, thanks very much, Joe, for the kind introduction, and I must say it's pretty daunting following in the footsteps this morning of Wardy. It's nice in this day and age to, particularly in the law, to see somebody so humble but who's so respected, and he's a champion and we all look up to him, and I just wish he hadn't stolen so many of the good points that I was about to make. But look, I'm conscious you've all got to get off to court, and I'm the last speaker. I am going to be a bit repetitive, but I'm talking about something a little bit different. I'm talking not about the situation where, as Wardy was, perhaps after having a few drinks at 10 o'clock at night and the phone rings and somebody is at Whoop Whoop Police Station and wants some advice, a record of interview is imminent. This is very different. What I'm talking about is a situation where you've got somebody who is facing a record of interview, but it's not imminent. It's something that the police are content to have down the track perhaps next week. And so you've got the opportunity to get the client in and say, let's consider the situation. What are the circumstances? What are our options? And it's a set of circumstances where you can make a judgment, develop an appreciation of the client. Is he intelligent? Is he articulate? Is he inarticulate? Is he unintelligent? Is he honest? Is he dishonest? And get a feel for him. And once you've got a feel for him and the way he is, the way he might go about the record of interview, it's really in that with that knowledge that you can really give the client good advice, informed advice. And so it is that in those set of circumstances, I imagine at the end of the day, there are essentially four options that are open to you, and that is to say no comment, to partially comment, to fully comment, or to produce a written statement in the record of interview. Now, you've got my paper. If you've got my paper, I'm not going to start at the first page. I'm going to take you to the second page and go straight to the options. What are the options? Well, the first option, it seems to me, is to make no comment. If you're in any doubt at all, the golden rule, it would seem, is to make no comment. Now, often a client sitting in your chambers or wherever you are is going to be thinking to himself, well, if I make no comment, that probably doesn't look very good. So tell the patient, I say patient because I often look after the doctors who are in this context of recent years, who are in trouble and facing sexual assault allegations, but tell the client what are the implications. If you go along and make no comment, what are the implications? What's going to happen at court if it goes to court? Well, you can tell the client that in terms of the evidence, the fact of the matter is the court will never be, the jury will never be appraised of the fact that you made no comment. So it's not a problem. Don't worry about that, client. If you go along and make no comment because the jury's not going to be aware of the fact, won't be acquainted with that fact. Tell the client how it is that at the end of the case, the judge talks to the jury. Now, it may be the case that for one reason or another, that the jury has become aware through a slip in the evidence or whatever, that the client has made a no comment record of interview. And so tell the client that if that comes out in the evidence, he shouldn't be so concerned because in terms of what the judge will say to the jury, the judge will tell the jury that it has to tell the jury that it can't draw an adverse inference from the fact that he's made such a record of interview. So giving that sort of advice to the client puts the client at ease, understands then that to make a no comment record of interview is not going to be seen as you, the client, hiding something. I think it's very important that when you're in conference with the client, you've made a judgment to make no comment, that the client ought to be alerted in no uncertain terms to the techniques that unscrupulous police officers will employ to get them to talk. And so it is that this is particularly important when you've got a client who's not particularly on the ball or intelligent or awake up to or is naive. You know, we're all familiar with the situation where the police say, and it's so frustrating and annoying, you hear the police officer saying to the client in the record of interview, you know, this is your opportunity to give your side of the story. We're giving you this, we're decent people, we're giving you the opportunity right now, if you'd like to, on camera, to give your version of the events. And it puts an enormous pressure on the client to think, oh gee, I better say something. If I don't, I'm in trouble here. So just alert them to that, because it's a common thing that's happening. And of course, we're all familiar with how it is that you get the nice police officer who's asking innocuous questions about who knows what, you know, the weather. The weather's been nice of late. The weather was nice last Wednesday. What were you doing last Wednesday? Oh, I was on the beach where the assault took place. Lulls them into a false sense of security, and before they know it, they're telling the police officer where they were last Wednesday. So just alert the clients to that difficulty that may arise, that technique which may be employed by the police. Now, it's my view that if a client's advised to make no comment means no comment. And no comment means, client, I'm telling you, no comment to every question. Oh, but can I just tell them, no comment to every question. Your name, your address, do you want to give your fingerprints? Matter for you, but DNA, etc., forensic sample, etc. But as to anything other than your name and address, no comment means no comment. Now, tell them that in no uncertain terms, because it's the most frustrating thing to emerge from a record of interview, read the record of interview, and see that there's been selective answering. I agree with Wardy. It looks bloody awful. If you're in the record of interview, and you're asked 40 questions, you're asked 200 questions, and then you get to the crucial bits, you say no comment, you might as well be saying, I did it. It looks terrible because the jury, it's just commonsensical this, if you're in the jury and you're listening to this fella being questioned, what happened next? I went over there, and then did you sit down at the table? Yes, I sat down at the table. Then you had a cup of tea? Yes. And I notice you've got blood all over your pants. Why is that? No comment. It looks terrible. It's a bad look. Juries hate it. You might as well be implicating yourself. And so tell the clients that, look, the implications of you making selective answering like that are pretty bad, because you can say to the judge when you get to court, look, judge, this selective answering, it's pretty prejudicial. And the judge might say yes, but in 9 out of 10 cases, the judge says, no, it's got to go into evidence. And so you can get it excluded. The jury is directed, and you can tell your client this, that the jury is directed that no adverse inference may be drawn from the fact that the accused answered some questions but didn't answer others, and that it can't afford evidence of a consciousness of guilt. But really, the advice you should be giving, without being too fine about it, is just don't answer some and not others. Just no comment throughout. And you have to be particularly strict about this. Second option, conscious of the time, the second option I suggest is to partially comment. A real problem with no comment records of interview is that they really put the police in an awkward position. Believe it or not, there are some police officers in Victoria who don't really necessarily want to prosecute the matter, don't necessarily want to charge your client with something. They're often put in a set of circumstances, particularly in sex cases, where the complainant is not particularly believable or doesn't present well, or they have the police doubts about this complainant, but she's very assertive. I want this matter pursued. Now, if you have, say, for example, somebody who is relatively inarticulate and not particularly smart, you might be worried about the person putting his foot in it if he goes into a record of interview situation, but you've really got to get on transcript in a record of interview a denial or a defence. So you might choose to partially comment, and what I mean by that is to say something along the lines of, I haven't done anything wrong, otherwise I make no comment, all throughout the record of interview. Just getting on, I haven't done anything wrong, then places on record a denial, places on record a defence. And so then the prosecution, the police, don't only have one side of the story, they've got the accused's side of the story as well. They've got a denial. And so it is that's much easier for them then to elect not to proceed to prosecute your client. If the client just made no comment, they've got one side of the story, not both sides. And so if there's a no comment record of interview, but you've got a complainant who's maintaining that she wants this pursued, even though the police are not very confident in her as a potential witness, they're more or less duty bound, aren't they, to prosecute if they've got nothing but a no comment from an accused. So if you partially comment, you are exploiting the possibility that the police might not charge a client. So the sorts of things that you might say is, I acted in self-defence, otherwise no comment, not selective answering, no comment throughout. She consented, or I thought she was consented, but otherwise no comment throughout. Look, the victim, if this alleged victim is saying I did this, that person has got a motive to lie. I'm not going to elaborate, but otherwise no comment throughout. And so it is that you have a denial, a simple statement of the defence, and otherwise no comment. And in those circumstances, you might find that the police might elect not to pursue your client with charges. Fully comment, that's the third option. It is the fact of the matter that I imagine that we used to advise people to make no comment because people generally, in the old days, used to be charged with criminal offences in circumstances where the overwhelming majority of them were people who were from lower socio-economic circumstances and who didn't have the advantage of formal education and who weren't able to articulate themselves, do themselves justice in a record of interview. So they couldn't explain themselves. If they even tried to explain themselves, they'd go backwards, even if they had a perfectly legitimate excuse for the circumstances that they found themselves in. These days it's a bit different. People from lower socio-economic circumstances are not the only ones being charged with criminal offences. These days it's very different, isn't it? And so you have even people from the lower socio-economic circumstances being more formally educated and articulate, certainly street smart, and so it is that they're able to perhaps go into a record of interview and articulate themselves. This is something that you have to make a judgment about. Does the client seem to be able to express him or herself well? And if it's the case that the client seems to be able to do that, all the more reason why you might want to make a full comment. But really, what you've got to do is you've got to sit down and just commonsensically say, look, what do you reckon they've got against you? Just as Wardy was saying, listen, this blue, it was, where did it happen? And they'll say, well, it was down near, No Federation Square. Well, we all know there are CCTV footage cameras down there. The last thing you're going to do is say to your client, go in and make a full comment record of interview in the knowledge that he's going to be saying, well, the first thing I did was this, and the second thing I did was that, and the third thing I did was that, and that's all I did. And then you see that he looks like Muhammad Ali on the CCTV footage. You've got to really discuss with your client, is it safe? Do you reckon there might be any DNA there? And you might find down the track that there is DNA there, and that won't come out. That evidence won't become available often until months down the track. And it's going to be particularly awkward, and Morty alluded to this, your defence would have to change, and that's very awkward. It is that there are a number of reasons why a full comment record of interview might be appropriate, and I've already discussed with how it is that you might want to do it to try to avoid a prosecution. It's often the case that, particularly in word against word cases, and as I've suggested, I act for a lot of doctors who are in circumstances where patients are making allegations that in relation to the intimate procedure that was conducted, it was conducted improperly, and so a rape charge evolves out of those circumstances, but they're essentially word against word cases. And if you're confident that the only evidence that they have is word against word and that there's no pretext conversation that's been obtained, find out from the client, has this complainant, this patient, in the case of the doctor, has she called you? Have you spoken to her? Because if she has since the occasion, you can be dead set certain that it's been recorded by the police. And you can be also confident that the police will not allude to the fact in a record of interview. They'll trap the client. They won't tell the client at the outset that there is this recorded conversation. They'll virtually cross-examine the client into a position and then say, have a listen to this. And so you want to, you might want to make a full comment record of interview to try to avoid a prosecution in circumstances where it's word against word. If you're confident that the only other evidence is the word of another person, then if your client gives a full version in a record of interview and is reasonable and sensible, sounds plausible, well really you're halfway to avoiding a prosecution, if not mounting a successful defence, aren't you? To set up a guilty plea. This is really important. I reckon it's not done enough. And the reason why I say this is because I'll never forget going back to the office one day when I think when Bob and Brian employed me about 100 years ago, and Rolfie said, how'd you had the plea go? I said, oh, disastrous. I said, what happened? I called my client. He said, you what? I wanted to make some points to the judge. Went backwards 100 miles an hour. But imagine if they'd been made in the record of interview. Imagine if you had said to the client before the record of interview, now look, this is how it works. We go into court and we tell the judge you're terribly sorry. We tell the judge about how it is that you've, all you do day in, day out is think about the victim and how the victim probably can't eat at all because the victim's got the victim's jaw wired up. And it just would be fantastic if, or you tell the client that what happens in a plea is that we tell the judge why it is that you did what you did. And it may be because the client was so extremely depressed. So then the client knows what to say in the record of interview if the client is going to plead guilty. And so you'll have your client in the record of interview saying, oh, it's so terrible, I can't stop thinking about this poor fellow's jaw I've broken, he can't eat his steak. Being facetious. But you can imagine how a client could develop that in a record of interview, and then you can point to that in the plea, and it's a great indication of contrition and remorse and so forth. It's always very important as well if the client is to say, look, I really know what I've done wrong here. I should not have done it this way. I should have handled it differently. And that goes to demonstrate that the client has insight into the wrongfulness of his acts, and you can point that out to the judge, and the judge will say, well, that gives me some insight into the fact that he's got insight, and that augurs well from a perspective of rehabilitation. We haven't got long to go. I just want to develop a few more points. You might want to make a full record of interview to set up a defence. It's fantastic if you've got a great record of interview as defence counsel, because it obviates the need often to call a client. As Dad, who's here, always said to me, you know, the height of the defence case is invariably at the close of the prosecution case. But how many times have we gone backwards when we've called our clients? It's really very difficult when that happens, and so if you can avoid calling your client, avoid calling your client. And the record of interview, if it's a full comment one, and it's a good one, will help you achieve that end. There are a number of pitfalls. The client's setting concrete, position is set in concrete. The client might set up a clash with what a co-accused might have said or might later on say in his record of interview. So if you know that there's a co-accused, ascertain if you can, if you've got time, what another co-accused has said or might be going to say. There's nothing wrong about that. The client, particularly if he's a dill, may unconsciously contradict something he said in the past. And as I say, the police won't always reveal that they've got a pretext conversation. They'll hit him with it at the end of the record of interview, and then your history. You've given a full version of events, the police may go and find evidence to contradict it. Despite their job being to investigate things, you'd swear on occasions that they form the view that their job is just to prosecute and convict people. But the jury may be able to infer a consciousness of guilt from the conscious omissions of certain acts, certain details. I'll give an example there. He might tell the police that he asked her if it was all right to have sex with her, but not reveal that he knew she was deaf. Really, should you if you're going to contest something, what should your position be? I tend to think that if you're proposing to defend, your safest option is to simply make no comment. You might, at the end of the day, give a lot of consideration to things, but your safest option is to give no comment. But I agree with Mark and Woody that if your version seems plausible, don't be too shy about fully commenting. It's really a judgment that you have to make, and it's often a difficult judgment. Finally, producing a prepared statement. It's seldom done, but you can turn up at the police station, and I understand Wardy likes to, if he goes down this path, attend the police station with a prepared statement, and in the presence of the police, before the record of interview commences, give them this prepared statement. However it's done, if the client in the record of interview is being asked, what's your name, what's your address, now let me take you to, and the client says, aha, look at this. I've got a statement, have a look at this, this is my position. I don't want to elaborate on it, that's my statement. I don't know whether there's really much that the police officer can do. He's stuck with it, I imagine. And I've just made, I've alluded to how it is that what you might like to incorporate at the commencement of that statement is a paragraph along the lines of that which is contained at the bottom of page 6, which is designed to demonstrate that I've got advice, this is what I want to do, I do not want to elaborate further, I feel I'm best able to express myself by doing things this way. I don't want to make any further comment. If you incorporate something into the document like that and the police then persist with questioning, you may be able to mount an argument that any of the subsequent questioning should be ruled inadmissible. And so it is that it's 9 o'clock or thereabouts, and you've got that document which hopefully will assist you, and thank you.
I realise it's 9 o'clock and many of you may have to rush off, but has anyone got any questions that they would like to address to any of the speakers this morning? Mr Cudler.
Looking to the very end, assuming the worst in your client's convicted, we frequently hear judges say they cooperated from the outset. Now, if you make a no record comment in an interview, and I don't know how much weight judges really put on people being cooperative from the outset or not. Let's say the golden rule, you make a no comment record in an interview. How much do you think that could take away from your sentencing material, your plea material?
None at all. None at all. They can't draw an adverse inference or punish you for exercising a right. But obviously, if you're given a version of events which is fully franked and a different story emerges, and you can develop how it is that you've been of assistance to the prosecuting authorities right from the outset. So, yeah.
I've got a question in relation to the diversion process.
It's a question in relation to the diversion process for those at the other end.
If you have a read on the Magistrates Court website, you'll see that it's typically for what's known as a first offence, or something that's got no prize. But when you look at the Criminal Procedure Act, it doesn't actually go into that. It doesn't even specify whether it applies to somebody with no prize. I might be mistaken.
No, you're absolutely right.
So it could be with someone...
Sorry, the question is the diversion process is set out as being someone without prize, but the Criminal Procedure Act doesn't articulate that.
You can, if I could, perhaps I had more, on more of the lower level than these boys. That's absolutely true what you've indicated. It's become a bit of a practice with JRs and magistrates that they look at your history, and I think we should push it more vigorously. When you are in the diversion process and you get the word from the clerk that the magistrate or the judicial registrar is against you, persist in making submissions. Don't readily, but be very polite of course, don't readily accept a knockback. You know how you fill in your form, you have your interview with your clerk, then it's referred to a magistrate or JR in chambers, and often the call comes back, no, they're not interested. Persist with your submissions, allude to the Criminal Procedure Act, you're absolutely right. It's become a bit of an unwritten practice, but your point is excellent in my view.
In relation to no comment, can you say no comment, but I reserve my right to produce a statement after I get reasonable advice?
What do you reckon?
And what's the impact of that?
I say no.
Yeah, I wouldn't go down that.
There's no utility in that in my view.
Because then if you don't produce something subsequently, probably doesn't look good.
Any other question? I've got a question. What's the panel's attitude with solicitors sitting in on the interview?
I prefer them not to. I don't know whether it's a good look. Also, you're potentially a prosecution witness. If you're going to have anyone sit in the record of interview, it's preferable that you have somebody else from your office sitting in on the record of interview. It's understandable though in circumstances where you might want to have somebody in there because the client is so terribly frightened of the whole process, and that's understandable if they might want somebody there. that you become a prosecution witness potentially. Do you agree with that?
Yeah.
There's really no advantage in it. And what can happen is if the client's asked a question,
I'm still doing
the course of the interview, and doesn't really know how to answer it, it's a bad look for them to be turning around to the solicitor and say, what am I going to say here?
The only exception to that might be a Section 19 examination, the ASIC examination, where the solicitor can assist you in prompting you to say privilege prior to every answer. But otherwise, I agree with Bob and Sean that you could find yourself being a prosecution witness.
On that point, is that when it's in relation to, I'm not too familiar with the ASIC Act, but I believe it's that you can't avoid an interview, is that right?
You have to answer questions.
You have to answer questions, so therefore a solicitor would be obviously required.
Exactly.
That's not admissible in criminal proceedings if it's the potential accused being subject to the examination. So
It's only admissible if in fact you lie and then you can be done for perjury.
I'd like to say I agree with Bob. What we do and what Bob taught us 100 years ago was that you'd take your client down to the police station, you'd let the police officer know that you were there, especially in the rough old days. I found that police treated clients a bit better. They're more professional these days, tapes, etc. And if they know you're hanging around, they're a bit more, they take into account your presence, but no way sitting on an interview. As Sean and Bob say, you can be a witness, and as Bob properly says, how bad does it look when the curly questions come and the guy turns to you? No, it's a no-no.
Any other questions from anyone? On behalf of Green's List, I'd like to thank everyone for getting up and coming on, making an early start, and I'd like to thank Sean, Peter and Mark for